In the hallowed halls of justice, where power and truth often engage in a delicate dance, few expected the quiet determination of Usha Vance to become the catalyst for one of the most remarkable courtroom confrontations in recent memory. The seasoned attorney, known for her methodical approach and unwavering principles, found herself standing before Judge Raymond Blackwell, a man whose reputation for rigid control over his courtroom preceded him. What happened next would not only challenge the very fabric of judicial authority, but would send ripples through the legal community for years to come. If you think justice is always served behind those imposing courtroom doors, this story might change your perspective forever. Comment where you're watching from today as we dive into a confrontation that began with a whisper and ended with a roar. The federal courthouse of Westlake stood like a monument to order and authority, its imposing marble columns and vast steps designed to humble those who sought justice within its walls. The morning sun cast long shadows across courtroom 7A, where the air hung heavy with tension. The polished oak benches were filled to capacity. The spectators, an unusual mix of law students, reporters, and concerned citizens, who had caught wind that today's proceedings might be anything but ordinary. Usha Vance moved with quiet purpose as she organized her documents at the defense table. At 45, she carried herself with the confidence of someone who had faced adversity and emerged stronger for it. Her dark hair was pulled back in a practical bun, her tailored navy suit neither flashy nor forgettable, much like her courtroom demeanor. What distinguished Usha was not her appearance, but the intensity in her eyes, windows to a mind that processed information with remarkable clarity and purpose. Judge Raymond Blackwell entered the courtroom with the practiced authority of a man accustomed to deference. At 62, his silver hair and permanent stern expression had become almost iconic in legal circles. His reputation for running an efficient courtroom was matched only by whispers of his intolerance for what he perceived as challenges to his authority. As he took his seat at the bench, his gaze swept across the room, lingering momentarily on Usha before he adjusted his robes with a deliberate motion. "All rise for the Honorable Judge Raymond Blackwell presiding," the bailiff announced, his voice echoing through the suddenly silent room. The proceedings began with the usual formalities, but keen observers noticed the subtle tension between the defense counsel and the bench. Judge Blackwell's interruptions came more frequently when Usha spoke, his questions sharper, his patience visibly thinner. The prosecution, led by Assistant District Attorney James Preston, seemed to receive a markedly different reception. His arguments met with thoughtful nods, his objections sustained with minimal deliberation. As the morning progressed, Preston presented the state's case against Maria Gonzalez with calculated precision. He painted a picture of a demonstration that had crossed the line from protected speech to public disruption, his rhetoric carefully chosen to transform peaceful protesters into agitators. Throughout his presentation, Judge Blackwell remained attentive, occasionally asking clarifying questions that seemed designed to strengthen the prosecution's narrative. "The state maintains that Ms. Gonzalez was not merely exercising her First Amendment rights, Your Honor," Preston concluded, "but rather coordinating actions specifically designed to obstruct public services and intimidate city officials." Judge Blackwell nodded thoughtfully. "Thank you, Mr. Preston. The court appreciates your thoroughness." Then, turning to the defense table with a noticeably cooler demeanor, he continued, "Ms. Vance, you may present your opening arguments, but I remind you that this court has no patience for long-winded constitutional lectures. The facts of this case are straightforward." The courtroom tensed at this unusual judicial commentary. Seasoned attorneys exchanged glances, recognizing that the judge had subtly revealed his position before the defense had uttered a single word. Usha Vance rose slowly, her expression betraying nothing of the strategic calculations happening behind her composed facade. "Thank you, Your Honor," she replied, her voice steady and measured. "The defense appreciates the court's guidance." Barely 10 minutes into her presentation, Judge Blackwell interrupted. "Ms. Vance, I believe I made myself clear about constitutional grandstanding. Please confine yourself to the specific actions of your client on the day in question." A ripple of surprise moved through the gallery. Even Preston, the prosecutor, shifted uncomfortably in his seat. Usha paused briefly, then continued with remarkable composure. "Your Honor, with respect, the The constitutional context is inseparable from the facts of this case. My client's actions can only be properly understood within... Ms. Vance, Judge Blackwell cut in, his voice sharper now. This court will determine what is relevant. I've made my ruling on this matter. Move on. The tension in the courtroom escalated as observers witnessed this unusual judicial intervention. Some of the law students in attendance began taking furious notes, recognizing they were witnessing something beyond the ordinary adversarial process. Usha stood perfectly still at the lectern, the only movement the slight narrowing of her eyes as she assessed her position. This moment marked the first visible collision between two formidable forces, a judge determined to control his courtroom and an attorney committed to justice beyond mere procedure. What no one in the courtroom yet realized was that this seemingly routine case would soon evolve into a defining moment for both Usha Vance and Judge Blackwell, a confrontation that would test not only the limits of judicial authority, but the courage of a woman who had spent her career fighting for those whose voices were too often silenced. As the morning session continued, the pattern became increasingly apparent. Judge Blackwell's interruptions grew more frequent and less subtle, his tone increasingly dismissive of Usha's arguments. When she attempted to introduce evidence of similar protests that had been protected under established precedent, the judge barred it as irrelevant. When she called her first witness, a constitutional law expert, Judge Blackwell limited the scope of questioning so severely that the testimony became nearly meaningless. By the time the court recessed for lunch, the gallery buzzed with quiet conversations. Seasoned court reporters recognized they were witnessing something unusual, not merely the typical friction between bench and bar, but something that bordered on judicial hostility. What they couldn't know was that the afternoon session would transform this simmering tension into a confrontation that would challenge the very foundations of courtroom decorum and judicial restraint. As the afternoon session commenced, the courtroom had filled to capacity, word having spread through the courthouse about the morning's unusual tensions. Legal interns squeezed onto benches normally reserved for family members, while several senior attorneys from neighboring courtrooms found reasons to observe the proceedings. Judge Blackwell surveyed the crowded gallery with thinly veiled displeasure before directing the bailiff to continue. The defense calls Dr. Eleanor Michaels, Usha announced, her voice carrying clearly through the now silent courtroom. Dr. Michaels, a distinguished sociologist whose research focused on protest movements and civil disobedience, took the stand with the measured confidence of someone accustomed to defending her expertise. As Usha began her questioning, she carefully established the witness's credentials before moving toward the heart of her defense, the sociological context that separated protected protest from criminal disruption. Dr. Michaels, in your expert opinion, did the actions of Ms. Gonzalez and her fellow protesters fall within the established patterns of constitutionally protected civil discourse? Before Dr. Michaels could answer, Judge Blackwell leaned forward. Ms. Vance, I've already ruled on the admissibility of constitutional arguments in this case. Rephrase your question or move on. Your Honor, Usha responded, maintaining perfect composure. The Supreme Court has established that the sociological context of public assembly is relevant in determining... Ms. Vance, Judge Blackwell interrupted, his voice rising, approach the bench, now. The gallery watched in tense silence as Usha walked forward. The court reporter continued typing as Judge Blackwell leaned down, his words ostensibly private, but his tone carrying enough for the first few rows to hear. Counsel, I will not have my rulings questioned in my courtroom. If you continue down this path, I will hold you in contempt. Do I make myself clear? Usha met his gaze steadily. Your Honor, with all due respect, the record should reflect that the defense believes these limitations are prejudicial to my client and inconsistent with established procedure. Judge Blackwell's face flushed slightly. The record will reflect what I determine it should reflect, Counselor. Return to your table and proceed appropriately. As Usha turned back toward her table, a subtle shift occurred in the courtroom. The morning's unease had crystallized into something more definitive, a recognition among the legal professionals present that they were witnessing not just rigid judicial management, but something that bordered on impropriety. Several court observers exchanged glances, and one senior attorney began making notes that had nothing to do with the case at hand. Usha adjusted her approach, asking Dr. Michaels more narrowly tailored questions about the specific actions observed during the protest. Even with these constraints, the expert's testimony began to construct a compelling picture. Maria Gonzalez had organized a protest that followed established norms of peaceful assembly, had coordinated with local authorities beforehand, and had actively worked to prevent escalation when counter-protesters arrived. Dr. Michaels, Usha continued, based on your review of the video evidence, did you observe Ms. Gonzalez engaging in or encouraging any actions that would constitute— Objection, Preston interrupted. Calls for a legal conclusion. Sustained, Judge Blackwell ruled immediately, without allowing Usha to respond. Your Honor, Usha said calmly, I'm asking for the witness's expert observation, not a legal conclusion. The objection has been sustained, Ms. Vance. Move on. The judge's tone had taken on an edge that silenced even the whispers in the gallery. For the next 40 minutes, this pattern repeated with increasing intensity. Usha would begin a line of questioning, only to have it restricted or redirected by judicial intervention. The prosecutor's objections were sustained with minimal consideration, while Usha's were dismissed with cursory explanations or none at all. Throughout, she maintained her composure, making brief notes and occasionally whispering to her client, whose anxiety was becoming visibly acute. The breaking point came when Judge Blackwell sustained an objection to evidence that he had allowed the prosecution to present just hours earlier, video footage of the protest from a particular angle. Your Honor, Usha said, her voice still measured but carrying a new firmness, I must respectfully note for the record that this identical evidence was admitted during the prosecution's case this morning. Judge Blackwell's gaze hardened. Ms. Vance, your continued challenges to this court's authority are becoming problematic. I am not challenging the court's authority, Your Honor, Usha replied. I am exercising my professional obligation to create a clear record and ensure my client receives equal protection under the law. A murmur rippled through the courtroom. Judge Blackwell slammed his gavel. One more word, counselor, and you will be in contempt. The silence that followed was electric. Prosecutors, defense attorneys, law students, all watched with collective breath held. In that moment, Usha Vance faced a choice familiar to advocates throughout history: acquiesce to maintain peace or stand firm at personal cost. Her decision would transform not just this case, but her career. She drew herself up to her full height, her voice clear and unwavering. Then, with respect, Your Honor, I move for your recusal from this case on grounds of demonstrable bias, and I request that the record reflect my formal objection to the disparate treatment of defense evidence and arguments. The courtroom erupted in hushed exclamations. The court reporters' fingers froze momentarily before resuming their work with renewed urgency. Judge Blackwell's face darkened with anger as he slammed his gavel repeatedly, demanding order. Ms. Vance, you are in contempt of court, he declared, his voice rising above the commotion. Bailiff, remove counsel to the holding area until she is prepared to show appropriate respect for these proceedings. As the bailiff approached, uncomfortable but duty-bound, the courtroom doors opened. A distinguished older man entered quietly, taking a seat in the back row. Few noticed his arrival amid the chaos, but those who did recognized Harold Winters, the chief judge of the federal district. His presence added yet another extraordinary dimension to an already unprecedented afternoon, setting the stage for a confrontation that would soon escalate beyond anything anyone in courtroom 7A could have anticipated. The presence of Chief Judge Winters in the back of the courtroom went unnoticed by Judge Blackwell, whose attention remained fixed on what he perceived as an unprecedented challenge to his authority. As the bailiff reluctantly approached Usha, a subtle shift occurred among the gallery. Several attorneys who had been observing the proceedings rose to their feet in silent protest. The court reporter continued typing furiously, documenting every word and reaction, aware that this transcript might soon become the subject of intense scrutiny. Your Honor, Usha spoke again, her voice steady despite the bailiff now standing at her elbow. I would like to state for the record that my motion for recusal is procedurally appropriate under Federal Rule 28, Section 455, which mandates that a judge disqualify himself in any proceeding where his impartiality might reasonably be questioned. Judge Blackwell's face had taken on a dangerous shade of crimson. "Ms. Vance, your legal theatrics do not impress this court. You have been found in contempt, and you will be removed until you are prepared to conduct yourself appropriately." The bailiff placed a hesitant hand on Usha's arm. In the gallery, Maria Gonzalez watched with growing distress as her advocate faced punishment for simply doing her job. Beside her, a young law student began frantically typing on her phone, the glow of the screen barely concealed as she documented what was unfolding. "Before I am removed, Your Honor," Usha continued with remarkable composure, "I respectfully request permission to make an offer of proof for the appellate record regarding the evidence you have excluded and the constitutional arguments you have barred." This standard legal request, designed to preserve issues for appeal, was procedurally routine, but in the charged atmosphere of Courtroom 7A, it landed like a challenge. Judge Blackwell's response was immediate and severe. "There will be no need for such an offer, Ms. Vance, as I am declaring a mistrial due to defense counsel's misconduct. This case will be reassigned and rescheduled." He turned to Maria Gonzalez, who sat frozen at the defense table. "Ms. Gonzalez, you would be well advised to seek new representation before your next court date." A collective gasp escaped from the gallery. Declaring a mistrial over such an exchange was extraordinary and potentially prejudicial to the defendant, who would now face the financial and emotional burden of a second trial. More concerning to the legal observers present was the implied threat to Usha's relationship with her client, an ethical line that judges rarely crossed. It was at this precise moment that Chief Judge Winters stood up from his seat in the back row. His movement created a ripple effect as spectators turned to see who had risen. Judge Blackwell, initially oblivious to the disturbance, followed the redirected gazes until his eyes landed on his superior. The color drained from his face almost as quickly as it had appeared. "Your Honor," Usha said, seizing the momentary distraction, "given that you have declared a mistrial, I move that my client be released on her own recognizance, pending the new trial date, as the prosecution has failed to establish that she presents either a flight risk or danger to the community." Judge Blackwell, clearly rattled by the presence of Chief Judge Winters, seemed to struggle to regain his composure. "That motion is denied. Bail continues as previously set." The unfairness of this ruling was not lost on anyone in the courtroom. Maria Gonzalez, a community organizer with deep local ties and no criminal record, had been assigned a $50,000 bail, an amount her community had struggled to raise through donations, and which would now be extended indefinitely due to the mistrial. Usha's voice took on a new edge of determination. "Then I request an immediate bail review hearing before a different judge, pursuant to Local Rule 46.1, which allows for reconsideration when circumstances have materially changed." "The declaration of a mistrial does not constitute a material change, Ms. Vance," Judge Blackwell responded, though his voice had lost some of its previous authority. "With respect, Your Honor, the declaration of a mistrial due to alleged defense misconduct that will be subject to bar review and judicial complaint proceedings does constitute a material change, as it creates a conflict of interest for Your Honor in continuing to make determinations about my client's liberty." The strategic brilliance of this argument was not lost on the attorneys present. By linking the mistrial declaration to a potential judicial complaint, Usha had created precisely the conflict of interest that would necessitate another judge reviewing the bail decision. More importantly, she had done so on the record, making it difficult for Judge Blackwell to continue making rulings that might later be scrutinized as retaliatory. Judge Blackwell appeared momentarily stunned by the legal trap Usha had constructed. Before he could respond, Chief Judge Winters moved from the back of the courtroom toward the front, his presence impossible to ignore. As he approached, a path cleared automatically among the spectators. "Judge Blackwell," the chief judge said, his voice carrying easily across the now silent courtroom, "I wonder if I might have a word with you in chambers before these proceedings continue." The request, though phrased as a suggestion, carried the unmistakable weight of administrative authority. Judge Blackwell's jaw tightened visibly, but he nodded. "This court will take a 30-minute recess," he announced, avoiding eye contact with Usha as he rose and exited the bench. As both judges disappeared into the chambers, the courtroom erupted into hushed conversations. The bailiff, no longer pursuing his order to remove Usha, returned to his post with evident relief. Maria Gonzalez turned to her attorney with questions in her eyes. "What just happened?" she whispered. Usha took her client's hand, speaking softly but with conviction. "The system is correcting itself, Maria. It doesn't always happen, but today, I think it will." Across the courtroom, James Preston, the prosecutor, sat reviewing his notes with a troubled expression. As a career prosecutor, he recognized that the morning's proceedings had compromised not just the defense's case, but the integrity of the prosecution as well. Any conviction obtained under such circumstances would face serious challenges on appeal. In the gallery, the senior attorneys who had risen in silent protest now gathered in small clusters, their expressions a mix of concern and admiration. The young law student who had been texting throughout the confrontation was now surrounded by classmates as she showed them the responses flooding in from her posts to legal forums. Respected practitioners and scholars from across the country were already weighing in on the constitutional implications of what had transpired. For Usha Vance, these 30 minutes represented the calm within a storm of her own making. She had risked her professional standing, potential jail time for contempt, and her relationship with a valued client, all to uphold principles that many in her profession acknowledged, but few were willing to defend at such personal cost. As she organized her notes and prepared for whatever would follow the recess, she remained unaware that this confrontation would soon extend far beyond Courtroom 7A, challenging assumptions about judicial authority that had gone unquestioned for decades. Behind the closed doors of the judge's chambers, a different kind of confrontation was unfolding, one that would determine not just the fate of Maria Gonzalez, but potentially the future of Judge Raymond Blackwell's career on the federal bench. Inside the judicial chambers, the atmosphere was charged with tension as Chief Judge Winters closed the heavy oak door behind them. The room, with its dark wood paneling and shelves lined with leather-bound legal volumes, had been designed to convey gravitas and tradition. Now it served as the private arena for a confrontation between judicial authority and accountability. "What exactly do you think you're doing, Raymond?" Chief Judge Winters asked, his voice low but intense. At 68, Harold Winters had served on the federal bench for nearly 3 decades. His reputation for fairness and jurisprudential precision had earned him respect from across the political spectrum. Judge Blackwell straightened his robes, attempting to project dignity despite his evident discomfort. "I was maintaining order in my courtroom, Harold. Ms. Vance was deliberately undermining my authority and turning these proceedings into a constitutional debate society." Chief Judge Winters moved to the window overlooking the courthouse plaza, his reflection superimposed against the afternoon light. "I observed the last 40 minutes of your proceedings, Raymond. What I witnessed was not a defense attorney undermining authority, but a judge systematically preventing counsel from creating an adequate record for her client." "You weren't there for the morning session," Blackwell countered defensively. "She's been challenging my rulings from the start, trying to turn a simple criminal trespass case into a First Amendment crusade." "And perhaps it is a First Amendment case," Winters replied, turning to face his colleague. "That's for the adversarial process to determine, a process that requires both sides to present their arguments fully." Outside in the courtroom, the 30-minute recess had transformed the gallery into a forum of hushed legal analysis. Senior attorneys who had witnessed similar confrontations in other jurisdictions shared war stories, while the row of law students continued documenting every detail for what would undoubtedly become case studies in judicial ethics seminars. Usha Vance remained at the defense table, outwardly composed as she reviewed her notes and occasionally reassured her increasingly anxious client. Inside, however, her mind raced through contingency plans. If Judge Blackwell returned determined to proceed, she would need to continue building a record of objections while avoiding actions that might legitimately justify the contempt charge. If a different judge were assigned, she would need to quickly prepare arguments for the bail review hearing she had requested. Prosecutor James Preston approached the defense table cautiously, conscious of the many eyes following his movement. "Ms. Vance," he began, his voice pitched low, "I want you to know that I did not anticipate or approve of how these proceedings have developed. My office is committed to fair process, regardless of our position on the merits. Usha looked up, measuring the sincerity in his expression. Preston was a career prosecutor with a reputation for tough but ethical advocacy. I appreciate that, James. Would the state be willing to join my motion for a bail review, given the circumstances? Preston hesitated, weighing professional loyalty against his ethical obligations. I can't oppose the judge's ruling directly, he said carefully, but I won't object to your motion being heard by another judge, and I'll acknowledge on record that the mistrial declaration was unrelated to any actions by the defendant herself. It was a small concession, but potentially significant for Maria Gonzalez's immediate freedom. Usha nodded her appreciation as Preston returned to the prosecution table, aware that his moderate stance might later be scrutinized by his superiors. In chambers, the confrontation between the judges had escalated. You declared a mistrial because counsel properly moved for your recusal, Raymond, Chief Judge Winters stated, his tone hardening. Do you understand the implications of that decision? You've burdened a defendant with the emotional and financial costs of a second trial because her attorney performed her ethical duty. Judge Blackwell's face flushed again. Vance was grandstanding, Harold, making a spectacle to impress her activist client and her friends in the public defender's office. That's not what I observed, Winters replied evenly. What I saw was a pattern of disparate treatment, sustaining prosecution objections without hearing full arguments, limiting defense evidence while allowing similar prosecution exhibits, interrupting defense counsel repeatedly. If Ms. Vance files a judicial complaint, which I expect she will, these actions will be difficult to explain. Are you threatening me? Blackwell asked incredulously. I'm reminding you of your oath, Raymond, the same one we both took. Winters moved to the desk, where a framed copy of the judicial oath hung alongside Blackwell's credentials. To administer justice without respect to persons, and do equal right to the poor and to the rich. As the recess approached its conclusion, the courtroom doors opened to admit several new observers. Among them was Catherine Morrow, the federal public defender for the district, accompanied by 2 assistant federal defenders. Their presence signaled that news of the confrontation had reached beyond the courthouse walls, drawing institutional attention to what had begun as a routine criminal case. In chambers, Chief Judge Winters had made his decision. Here's what's going to happen, Raymond. You're going to return to the bench and vacate your contempt finding against Ms. Vance. You're going to grant her motion for recusal, not because she demanded it, but because it's the right thing to do. You're going to transfer this case to the general docket for reassignment, and you're going to grant the bail review hearing before the newly assigned judge. And if I refuse? Blackwell challenged, though his tone lacked conviction. Then I will convene an emergency meeting of the Judicial Council this evening to discuss your pattern of conduct in this and other recent cases, Winters replied calmly. Several complaints have already been filed, Raymond. I've been trying to handle them administratively, but today's display forces my hand. The revelation that other complaints existed seemed to deflate Judge Blackwell's remaining resistance. He sank into his chair, suddenly looking older than his 62 years. You've made your point, Harold. I'll recuse myself. Good, Winters nodded. And Raymond, consider taking some leave. The stress of this position affects us all, but how we manage it defines our fitness for the bench. As the bailiff called the courtroom back to order, the gallery fell silent, all eyes fixed on the door through which the judges would return. When it opened, only Judge Blackwell emerged, Chief Judge Winters having chosen to remain in chambers rather than appear to supervise a colleague's courtroom. Judge Blackwell took the bench, his expression inscrutable as he adjusted his robes and surveyed the packed courtroom. The tension was palpable as attorneys, defendants, spectators, and court personnel awaited his next words. After careful consideration, he began, his voice noticeably modulated compared to his earlier tone. This court grants the defense motion for recusal. The contempt finding against Ms. Vance is vacated, and this case will be transferred to the general docket for reassignment to another judge. He paused, visibly struggling with the next part. A bail review hearing will be scheduled before the newly assigned judge within 24 hours. A collective release of tension swept through the courtroom. Maria Gonzalez grasped Usha's hand under the table, tears of relief threatening to spill from her eyes. The law students in the gallery exchanged triumphant glances, while the senior attorneys nodded in somber approval. Judge Blackwell, having completed the requirements set by Chief Judge Winters, gathered his dignity for a final pronouncement. This court is adjourned. With a single tap of his gavel, he rose and exited the bench for what would be the last time in this case. As the courtroom began to empty, Usha Vance remained seated, the magnitude of what had transpired settling over her. She had risked her professional standing to uphold principles that many acknowledged, but few were willing to defend at such personal cost. The confrontation that had begun with a judge's attempt to silence her had instead amplified her voice, and with it, the fundamental promise that justice requires courage as much as it demands law. The story of Usha Vance's courtroom confrontation with Judge Blackwell spread through legal circles with remarkable speed. By evening, what had begun as a routine criminal case had transformed into a flashpoint discussion about judicial temperament, the limits of courtroom authority, and the obligations of defense counsel. News outlets had picked up the story, their headlines ranging from measured accounts of unusual judicial recusal in federal court to more sensational takes on attorney stands ground against federal judge and wins. For Usha, however, the immediate aftermath was focused not on the broader implications, but on securing her client's freedom. The day following the dramatic recusal, Maria Gonzalez's case was assigned to Judge Eliza Sandoval, a recently appointed jurist known for her methodical approach and scrupulous fairness. The bail review hearing was scheduled for that same afternoon, giving Usha precious little time to prepare her arguments. The courtroom assigned to Judge Sandoval was smaller than Judge Blackwell's, but it too filled to capacity as word spread about the hearing. Many who had witnessed the previous day's confrontation returned, joined by a new contingent of legal observers curious to see the aftermath. Among them was a distinguished silver-haired man whose presence caused a subtle stir among the attorneys present, Samuel Vance, a respected constitutional scholar and Usha's father. Judge Sandoval entered the courtroom with a deliberate lack of ceremony, her approach to judicial authority markedly different from Judge Blackwell's. After the standard opening formalities, she addressed the attorneys directly. "I've reviewed the case file and the transcripts from yesterday's proceedings," she began, her tone professional but not cold. "This hearing is limited to the question of pretrial release conditions for Ms. Gonzalez. Ms. Vance, you may present your arguments." Usha rose, conscious of the many eyes upon her, but focused entirely on her client's needs. "Thank you, Your Honor. The defense moves for release on personal recognizance, as Ms. Gonzalez has deep ties to this community, no criminal history, and poses no risk of flight or danger to others." She proceeded to outline Maria's background: 20 years of residency in Westlake, leadership roles in community organizations, a stable job as a youth counselor, and custody of 2 teenage children. These were standard arguments in bail hearings, but Usha delivered them with a conviction that transformed routine legal factors into the human story of a woman whose continued detention served no legitimate purpose. When she finished, Judge Sandoval turned to the prosecution. "Mr. Preston, does the state have a position on the defense motion?" James Preston stood, his demeanor noticeably different from the previous day. "Your Honor, while the state originally requested the current bail amount based on concerns about the organized nature of the protest activity, we do not oppose a modification of release conditions at this time. The defendant's community ties are well established, and the state acknowledges that she appeared for all prior court dates as required." This subtle but significant concession caused a murmur in the courtroom. Judge Sandoval allowed it to subside before speaking again. "Based on the arguments presented and the court's review of the record, defendant Maria Gonzalez is released on her own recognizance, with the condition that she continue to appear for all scheduled court dates." The judge's ruling was followed by a brief discussion of scheduling for the new trial, now set to begin in 6 weeks. Throughout these procedural matters, Usha maintained her professional composure, though the relief in her client's eyes mirrored her own internal satisfaction. As the hearing concluded and the courtroom began to clear, the hidden dynamics that had been simmering beneath the surface of the case began to emerge more clearly. Near the back of the gallery, Catherine Morrow, the federal public defender, was deep in conversation with 2 civil rights attorneys who had attended both days' proceedings. Their animated discussion suggested that the implications of Judge Blackwell's behavior and subsequent recusal might extend beyond this single case. Usha gathered her materials at the defense table, explaining to Maria the next steps in preparing for trial. As they walked toward the courtroom exit, they were approached by a young woman who had been sitting among the law students. "Ms. Vance," she said, her voice betraying both nervousness and admiration. "I'm Elena Diaz, a second year at Westlake Law. What you did yesterday, standing up to Judge Blackwell like that, it's why I wanted to become a lawyer in the first place." Usha smiled at the young woman, recognizing in her earnestness echoes of her own early career idealism. "It wasn't about standing up to a judge, Elena. It was about standing up for the principles that make our system work. There's a difference." As Elena nodded her understanding, Samuel Vance approached, his expression a mix of paternal pride and professional respect. "Well handled, counselor," he said simply. "Thanks, Dad," Usha replied, the formality in her voice softening slightly. Their relationship had always blended the personal and professional, a shared commitment to constitutional principles, serving as a bond as strong as blood. While these personal exchanges unfolded in the courtroom, a more consequential meeting was taking place in Chief Judge Winter's chambers. There, Judge Blackwell sat across from the Chief Judge and two members of the Judicial Council, facing questions about not just the previous day's events, but a pattern of behavior that had apparently been concerning his colleagues for some time. "This isn't an isolated incident, Raymond," one council member was saying, her tone regretful rather than accusatory. "We've received complaints from at least 7 attorneys in the past year, all citing similar concerns about disparate treatment, particularly in cases involving constitutional claims." Judge Blackwell's initial defensiveness had given way to a troubling realization that his judicial legacy was now at risk. "I've always prided myself on running an efficient courtroom," he responded, his voice lacking its usual authority. "Perhaps in pursuing efficiency, I've been too quick to limit arguments I considered tangential." "Efficiency serves justice only when it doesn't compromise fairness," Chief Judge Winters observed. "The transcript from yesterday shows more than just impatience, Raymond. It shows a systematic favoring of the prosecution and a dismissiveness toward defense counsel that raises serious questions about impartiality." As this reckoning continued behind closed doors, its catalyst was navigating her own professional aftermath. Leaving the courthouse with Maria Gonzalez and her father, Usha was approached by James Preston, the prosecutor whose subtle shift in position had contributed to the successful bail hearing. "Ms. Vance," he called, quickening his pace to catch up with them. "A moment, if you don't mind." Samuel Vance and Maria continued toward the courthouse steps, giving Usha and the prosecutor privacy for their exchange. "That was decent of you in there," Usha acknowledged, referencing his decision not to oppose the bail modification. Preston nodded, his expression suggesting internal conflict. "It was the right call, but that's not why I wanted to speak with you." He hesitated before continuing. "The U.S. Attorney is reviewing all of Judge Blackwell's recent cases for potential due process concerns. There's talk of voluntary disclosures to defense counsel in at least a dozen matters where similar patterns emerged." This revelation represented a significant development, an acknowledgement from the prosecution that the issues exposed in Maria's case might have compromised justice in other proceedings as well. It also signaled that Usha's willingness to challenge judicial overreach could have implications far beyond her own client's case. "That's the right thing to do," Usha replied, her tone measured but appreciative. "The system works only when all its parts maintain their integrity." As Preston nodded and turned to leave, Usha rejoined her father and client on the courthouse steps. The late afternoon sun cast long shadows across the plaza, where a small group of community supporters had gathered to welcome Maria back to freedom. Their cheers and embraces formed a poignant counterpoint to the serious legal principles that had been at stake. Standing slightly apart from this celebration, Samuel Vance turned to his daughter. "You've stirred quite the hornet's nest, Usha." She smiled slightly, watching as Maria was embraced by her teenage children. "Some nests need stirring, Dad. You taught me that." What neither of them could know in that moment was that the confrontation in Courtroom 7A would continue to reverberate through the judicial system, eventually leading to consequences that would transform not just Judge Blackwell's career, but the very culture of the federal courthouse in Westlake, a transformation that would begin to unfold in the coming days through channels that none of the participants had anticipated. The reverberations of Usha Vance's confrontation with Judge Blackwell continued to expand in the days following the bail hearing. What had begun as a principled stand in a single case had evolved into a catalyst for broader scrutiny of judicial conduct throughout the district. The courthouse, normally a place of measured procedures and predictable rhythms, now hummed with an unusual energy as attorneys reviewed past cases for signs of similar treatment, court staff whispered about closed-door meetings of the Judicial Council, and administrators fielded an unprecedented volume of media inquiries. 5 days after Maria Gonzalez's release, Usha arrived at her modest law office to find Catherine Morrow, the federal public defender, waiting in the reception area. Though they had crossed paths professionally many times over the years, their relationship had been one of collegial respect rather than personal friendship. "Catherine," Usha greeted her with genuine surprise. "I didn't realize we had a meeting scheduled." "We don't," Catherine replied, rising from her seat. "But after what's happened, I thought a conversation might be worthwhile. Do you have a few minutes?" Usha led the way to her office, a space that reflected her approach to law, practical and unpretentious, with walls lined with constitutional texts rather than the ornate law school diplomas and bar admissions that adorned many attorneys' offices. The window overlooked a small community garden that Maria Gonzalez had helped establish years earlier, a fitting reminder of the real-world impact of legal advocacy. "I've been reviewing our office's cases before Judge Blackwell," Catherine began once they were seated. "The pattern you exposed isn't isolated to Maria's case. We've identified 27 matters in the past 18 months where similar issues arose. Defense motions denied without proper consideration, prosecution evidence admitted over valid objections, constitutional arguments curtailed or dismissed outright." Usha nodded, unsurprised, but troubled by the confirmation of her suspicions. "Have you taken this to the Judicial Council?" The proposal represented a significant commitment beyond Usha's obligations to her own clients, time and resources she couldn't easily spare as a solo practitioner. Yet the opportunity to address a systemic issue, rather than just its symptoms in individual cases, was precisely the kind of advocacy that had drawn her to law in the first place. "I'm in," she said simply. "What's the next step?" Catherine smiled, though her expression remained serious. "We're convening a working group tomorrow evening at the public defender's office. 7 attorneys who've had similar experiences with Judge Blackwell, plus 2 ethics professors from the law school who've agreed to review our documentation. If you can be there, your perspective would be invaluable." As Catherine departed, Usha turned to the stack of files awaiting her attention, including Maria Gonzalez's case. Judge Sandoval had scheduled a status conference for the following week, and despite the victory in securing Maria's release, the underlying charges remained. The mistrial had given Usha a second chance to present her constitutional arguments, this time hopefully before a judge willing to consider them fully. That afternoon, across town in the federal courthouse, Judge Raymond Blackwell sat alone in his chambers, contemplating the rapid unraveling of his carefully constructed judicial persona. On his desk lay a letter from the Chief Justice of the Circuit Court, acknowledging receipt of multiple complaints regarding his conduct and initiating a formal review process. The language was bureaucratic and measured, but the implications were clear. His actions were now subject to scrutiny far beyond Chief Judge Winter's administrative oversight. A knock at his door interrupted these somber reflections. His judicial assistant entered, her usual efficiency tinged with evident discomfort. "Your Honor, the clerk's office asked me to inform you that the Reynolds case has been reassigned to Judge Chen and the Martinez trial to Judge Davenport. That makes 7 cases transferred from your docket since Monday." Judge Blackwell nodded, dismissing her with a wave. The systematic removal of cases from his docket, particularly those involving constitutional claims or represented by attorneys who had previously appeared before him, represented a quiet but unmistakable vote of no confidence from court administration. As evening fell, the disparate participants in this unfolding drama found themselves drawn together by forces they hadn't anticipated. Usha, having worked later than usual preparing for the coalition meeting, stopped at a small bistro near the courthouse for dinner. As she waited for her order, she noticed James Preston, the prosecutor from Maria's case, seated alone at a corner table, reviewing documents with the intense focus of a man seeking answers in fine print. Their eyes met briefly, and after a moment's hesitation, Preston gestured to the empty chair across from him. Professional courtesy and genuine curiosity led Usha to accept the unspoken invitation. "Long day?" she asked, noting the scattered papers and half-empty coffee cup that suggested he had been there for some time. "You could say that," Preston replied, gathering the documents into a more orderly stack. "The U.S. Attorney has us reviewing every case Judge Blackwell has presided over in the past 2 years. It's enlightening." The careful choice of words spoke volumes. In the adversarial system, prosecutors and defense attorneys rarely discussed ongoing reviews of judicial conduct, each bound by different professional obligations and institutional loyalties. "Enlightening how?" Usha pressed gently, respecting the boundaries, but sensing Preston's need to process what he was discovering. He hesitated, then spoke in a lower voice. "I always thought of myself as an ethical prosecutor, someone who fought hard but fair. But looking at these transcripts, seeing the pattern of rulings that consistently favored our arguments, often without proper consideration of defense positions, I have to wonder if I benefited from an uneven playing field without recognizing it." This moment of professional self-reflection revealed the ripple effects of Usha's confrontation, extending beyond institutional responses to personal reckonings. For every Judge Blackwell whose conduct came under scrutiny, there were prosecutors who had to question whether victories had been fairly won, defense attorneys who wondered if they should have challenged judicial bias more forcefully, and clients whose faith in the system had been either validated or further eroded. "Recognition is the first step toward correction," Usha offered, neither absolving nor condemning. Preston nodded, meeting her gaze directly. "The U.S. Attorney is considering filing joint motions for review in cases where the imbalance appears to have affected outcomes. It's unprecedented, at least in this district." The significance of this development was not lost on Usha. Such an admission from the prosecution could open doors for clients who had been silenced not just by Judge Blackwell, but by a system that often placed procedural finality above substantive justice. As they parted ways outside the bistro, the evening air carried a hint of approaching autumn, a season of transition and transformation that seemed fitting for the changes unfolding in their professional world. "Why did you do it, Usha?" Preston asked unexpectedly as they prepared to head in opposite directions. Challenge him so directly, knowing the risks. Usha considered the question, looking past Preston toward the courthouse that loomed in the distance, its classical facade illuminated against the darkening sky. "Because silence in the face of injustice makes us complicit in it," she answered simply, "and because sometimes the system needs those within it to remind it of its own ideals." As she walked away, Usha remained unaware that at that very moment, in a conference room on the top floor of that illuminated courthouse, the Judicial Council was reaching a decision that would transform her individual act of courage into a catalyst for institutional change, a decision that would be announced the following morning and would irrevocably alter the landscape of justice in their community. The morning brought a crystalline clarity to Westlake, the kind of sharp autumn day when every edge seems defined with unusual precision. Usha arrived at the courthouse early, planning to review several cases before the coalition meeting Catherine Morrow had organized. The building's morning routine appeared unchanged, security officers checking IDs, attorneys rushing through metal detectors, couriers delivering documents. But an underlying current of tension suggested that something significant was brewing beneath this veneer of normalcy. As Usha passed through security, she noticed an unusual gathering of court staff near the administration offices. Their hushed conversations ceased when they noticed her, replaced by nods of acknowledgement that carried a new weight of respect. Word had clearly spread about her role in the confrontation with Judge Blackwell, transforming her from just another defense attorney into something more symbolic in the courthouse ecosystem. She had nearly reached the law library when Elena Diaz, the law student who had approached her after the bail hearing, rushed toward her with evident excitement. "Ms. Vance, have you seen the announcement?" The young woman thrust her phone forward, displaying the federal court's official website. "They just posted it 15 minutes ago." Usha took the phone, her expression shifting from curiosity to astonishment as she read the formal notice from Chief Judge Winters. Effective immediately, the Honorable Raymond Blackwell has taken a leave of absence from his judicial duties pending completion of a comprehensive review by the Judicial Council. During this period, Judge Blackwell's docket will be redistributed among other judges in the district. In addition, the Council has established a special committee on judicial conduct and procedural fairness, which will review court procedures and recommend reforms to ensure equal access and treatment for all parties appearing before the court. The notice continued with bureaucratic details about case reassignments and interim procedures, but the essential message was clear. Judge Blackwell had been effectively suspended, and the issues Usha had exposed were being addressed at an institutional level. "This is unprecedented," Elena said, her voice hushed with the gravity of the moment. "Professor Harrington said he can't remember the last time a federal judge was placed on leave like this, at least not in this circuit." Usha returned the phone, trying to process the implications. What had begun as a principled stand in a single case had catalyzed actions that would affect hundreds of matters and potentially reshape how justice was administered throughout the district. "Ms. Vance," Elena continued, her expression shifting from excitement to earnest determination. "A group of us from the law school clinic want to help. We've been tracking cases with similar patterns to Ms. Gonzalez's, creating a database of transcripts and rulings. Professor Harrington said it could be valuable for the special committee's review." This spontaneous mobilization of support underscored how quickly the confrontation had evolved from an individual act to a movement. Whether Usha had intended it or not, she had become the focal point for long-simmering frustrations about judicial overreach and procedural inequities. "That's excellent work, Elena," Usha responded, recognizing the importance of channeling this energy constructively. "Bring what you've compiled to the coalition meeting at the Public Defender's Office this evening. Catherine Morrow is coordinating our formal response to the Judicial Council." As Elena departed with renewed purpose, Usha continued to the law library, finding it unusually populated for early morning. Attorneys from various practices, corporate firms, solo practitioners, legal aid lawyers, huddled over shared documents, their typical competitive boundaries dissolved by common interest in the unfolding situation. Several nodded to Usha as she entered, their expressions conveying a complex mix of admiration, curiosity, and in some cases, the lingering caution of those who practiced regularly before Judge Blackwell and feared eventual repercussions. Usha had just settled at a research terminal when her phone buzzed with a message from Maria Gonzalez. "Have you seen the news about the judge? Does this mean my case will be dismissed?" The question reflected the personal stakes that remained at the center of what was becoming a broader legal drama. For Maria, the institutional reforms and judicial accountability were secondary to her immediate concern, the charges that still threatened her freedom and reputation. Usha typed a measured response. "I've seen it. This doesn't automatically dismiss your case, but it strengthens our position. Let's talk after your work shift today." As she set her phone aside, Usha noticed James Preston entering the library, his expression suggesting he had also just learned of the dramatic developments. Their eyes met briefly across the room, and he gave a slight nod that acknowledged their shared, if different, roles in the unfolding events. Before Usha could return to her research, her phone rang, her father's number displaying on the screen. She stepped into the library's quiet room to take the call. "I assume you've heard," Samuel Vance said without preamble, his voice carrying the measured tone of someone who had witnessed many legal battles over his long career. "Just now," Usha confirmed. "I'm still processing what it means." "It means the system is capable of self-correction when pushed hard enough," her father replied. "But it also means you're now in a spotlight you didn't ask for. The legal community has a long memory, Usha, both for those who challenge its foundations and those who force necessary change." His words carried the weight of experience and concern, not just as a father, but as a mentor who understood the professional landscape his daughter was navigating. The legal profession's complex power structures meant that courage was not always rewarded, and institutional change often came at personal cost to those who initiated it. "I didn't do this for attention, Dad," Usha responded, watching through the glass partition as more attorneys filed into the library, the buzz of conversation visibly increasing as news of Judge Blackwell's leave spread. "I know that," Samuel assured her, "but intention doesn't control consequence. You've become a symbol now, to some, of principled resistance, to others, of threatening the judicial hierarchy. Both perceptions will shape your practice going forward. As if to confirm his warning, Usha's email notification chimed, revealing a message from a prominent civil rights organization requesting her participation in a panel discussion on judicial accountability. This was the first of what would likely be many such invitations, each requiring her to balance her primary obligations to clients like Maria Gonzalez against the broader platform she had inadvertently created. By mid-morning, the courthouse was alive with speculation about what would follow Judge Blackwell's leave of absence. Court staff exchanged rumors about shouting matches in chambers and late-night meetings of the Judicial Council. Attorneys debated whether cases decided by Blackwell would be subject to special review procedures. Even the courthouse security officers seemed affected by the charged atmosphere, their usual banter replaced by attentive observation of the day's unusual dynamics. For Usha, the most significant confirmation of the morning's developments came in an unexpected form, a brief, formal email from Judge Sandoval's chambers. United States versus Gonzalez. Status conference moved to tomorrow, 9 a.m. Counsel should be prepared to discuss constitutional dimensions of charges in light of relevant First Amendment precedent. This subtle but unmistakable signal indicated that Judge Sandoval was inviting precisely the constitutional arguments that Judge Blackwell had attempted to silence, a vindication of Usha's initial strategy and a potential pathway to justice for Maria Gonzalez. As Usha gathered her materials and prepared to leave the courthouse, she passed the now empty courtroom 7A, where the confrontation had occurred. Through the partially open door, she could see court staff removing Judge Blackwell's nameplate from the bench, a small but powerful symbol of how quickly the seemingly immutable structures of judicial authority could change when their foundations were properly challenged. What awaited Usha beyond those courthouse doors was a community mobilizing around the principles she had defended, a coalition of advocates, scholars, and citizens prepared to transform an individual stand for justice into a movement for systemic change. The path forward would not be simple or straight, but in forcing open the doors that had been closed to her client's constitutional claims, Usha had created an opening through which many others might now follow. The coalition meeting at the Federal Public Defender's Office exceeded all expectations. What Catherine Morrow had initially envisioned as a gathering of 7 or 8 attorneys had swelled to over 30 legal professionals crowded into the office's largest conference room. They represented every facet of the district's legal community: seasoned criminal defenders, civil rights attorneys, law school clinic supervisors, and even several prosecutors who had quietly arrived after ensuring their superiors wouldn't be attending. Elena Diaz and 5 fellow law students set up in the corner, their laptops displaying the database they had compiled, a systematic catalog of Judge Blackwell's rulings, organized by case type, attorney, and constitutional issues involved. The patterns they had documented provided empirical weight to what many had experienced as individual instances of judicial overreach. Catherine called the meeting to order with a practiced efficiency that reflected her years managing an overworked public defender's office. Thank you all for coming on such short notice. I think we can agree that today's announcement about Judge Blackwell represents an opportunity we couldn't have anticipated a week ago. She gestured to Usha, seated midway down the conference table. Many of you witnessed or have heard about Ms. Vance's confrontation in Courtroom 7A. What began as one attorney's stand for her client has opened a door for addressing systemic issues that have affected many of our clients for years. Usha felt the weight of attention shift toward her, not the adversarial scrutiny of a courtroom, but the appreciative recognition of colleagues who understood exactly what she had risked. She acknowledged their looks with a small nod, uncomfortable with being positioned as the catalyst, but recognizing the importance of the moment. Our goal tonight, Catherine continued, is twofold. First, to organize our collective experiences into a coherent submission for the Judicial Council's Special Committee. Second, to ensure that what happened with Judge Blackwell leads to meaningful reforms rather than just a change in personnel. The meeting evolved into a remarkably structured exchange, with attorneys sharing specific experiences that reflected patterns in Judge Blackwell's courtroom, constitutional arguments summarily dismissed, defense experts subjected to hostile questioning, while prosecution witnesses received deferential treatment, bail decisions that seemed to reflect socioeconomic bias rather than legitimate risk factors. One of the law professors, a former federal prosecutor turned ethics scholar, guided the discussion toward institutional solutions. We need to focus not just on what went wrong, but on what structures would prevent similar problems in the future. Procedural reforms, transparent standards for judicial recusal, meaningful appellate review of discretionary rulings. These are the changes that outlast any individual case or judge. As the meeting approached its third hour, the discussion turned to a delicate but inevitable question. What would happen to cases already decided by Judge Blackwell, where similar patterns might have affected outcomes? Some of my clients are serving sentences based on trials where Judge Blackwell systematically prevented presentation of constitutional defenses, noted a veteran defense attorney. Do we have an ethical obligation to seek review of those convictions now? This question highlighted the complex intersection of individual justice and systemic reform. Each case represented a person whose life had been directly affected by judicial conduct that was now under official scrutiny, yet the legal system's emphasis on finality created significant barriers to reopening concluded matters. James Preston, who had remained silent for most of the meeting, finally spoke from his position near the door. As I mentioned to Ms. Vance earlier this week, the U.S. Attorney's Office is conducting its own review of cases where Judge Blackwell's conduct may have affected fundamental fairness. I can't speak officially for the office, but I believe there's willingness to consider joint motions for review in cases where clear prejudice can be demonstrated. This unprecedented offer from the prosecution side created a palpable shift in the room's energy. For attorneys accustomed to battling an often unyielding system, the possibility of cooperative remedial action represented a rare alignment of institutional power and ethical principle. If that's the case, said Catherine, we should establish criteria for identifying priority cases, focusing first on those involving substantial liberty interests, where procedural fairness was most compromised. As the meeting continued, Usha found herself in conversation with Elena and the other law students during a short break. Their enthusiasm was tempered by analytical precision as they explained the methodology behind their database. We've identified 87 cases in the past 3 years where Judge Blackwell specifically prevented defense counsel from making constitutional arguments, Elena explained, displaying a color-coded spreadsheet. The pattern becomes even clearer when you filter by attorney gender and race. The charts on her screen told a troubling story. Female attorneys and attorneys of color had been interrupted, limited, and sanctioned at significantly higher rates than their white male counterparts in Judge Blackwell's courtroom. What had begun as a concern about constitutional arguments had revealed a deeper pattern of disparate treatment that cut across multiple dimensions of identity and representation. This is excellent work, Usha acknowledged, recognizing that the students had captured empirically what many attorneys had experienced individually. Have you considered publishing this as part of a law review article? This kind of data could inform judicial training and evaluation across jurisdictions. Elena's eyes widened at the suggestion. We hadn't thought that far ahead. We just wanted to help with the immediate situation. Sometimes the most valuable contributions come from those who see patterns others have normalized, Usha replied, thinking of how her own challenge to Judge Blackwell had begun with a simple refusal to accept what many had come to see as business as usual. As the meeting concluded, Catherine outlined next steps. Working groups were established to draft the formal submission to the Judicial Council, compile case histories for potential review, and develop proposed procedural reforms. What had begun as an ad hoc response to a crisis was evolving into a structured movement for change. Outside the federal public defender's office, the evening had brought a gentle rain to Westlake, washing the day's heat from the streets and creating pools of reflected light on the sidewalks. Attorneys departed in small groups, their typical professional isolation temporarily suspended by shared purpose. For many, this was the first time they had worked collaboratively across the usual boundaries of practice area and institutional affiliation. Usha walked toward her car alongside Elena and 2 other law students, their youth and idealism providing a reminder of why the evening's work mattered beyond immediate cases and careers. "Do you think anything will really change?" one of the students asked, voicing the skepticism that often accompanied idealism. "Once the attention dies down, won't things just go back to how they were?" Usha considered the question seriously, recognizing both its naivety and its legitimacy. Change in the legal system rarely happens in dramatic moments, she finally responded. It comes through persistent effort that transforms extraordinary challenges into new baselines of expectation. What matters isn't just Judge Blackwell's leave of absence, but what we collectively build in the space it creates. As she drove home through the rain-slicked streets, Usha's thoughts returned to Maria Gonzalez and tomorrow's status conference. While the coalition worked toward systemic reforms, her immediate obligation remained to the client whose case had sparked this movement. Judge Sandoval's invitation to discuss constitutional dimensions suggested an openness to the very arguments Judge Blackwell had attempted to silence, a small but meaningful victory in itself. Arriving home, Usha found a package leaning against her front door, a newly published constitutional law treatise with a note in her father's distinctive handwriting. For moments when principle and opportunity align, you've made this old professor proud. Dad. The simple gesture carried the weight of generational connection, a reminder that her confrontation with Judge Blackwell existed within a longer tradition of attorneys who had challenged authority when necessary to uphold deeper principles of justice. As she prepared for the next day's hearing, Usha felt the dual responsibility of honoring that tradition while helping to forge its next chapter through the coalition that had formed in response to her stand in Courtroom 7A. The morning of Judge Sandoval's status conference brought with it an atmosphere of cautious optimism. Usha arrived at the courthouse early, finding the hallway outside Courtroom 3B already lined with observers, law students, attorneys with no direct connection to the case, and community members who had supported Maria Gonzalez throughout her legal ordeal. Their presence transformed what would typically have been a routine procedural hearing into something that felt more consequential, a public referendum on the principles that had been at stake in the confrontation with Judge Blackwell. Maria arrived 15 minutes before the scheduled start, accompanied by her teenage children and several fellow community organizers. She appeared both nervous and resolute, the weight of being at the center of a case that had taken on broader significance evident in her careful posture and measured greetings to supporters. "Is it always going to be like this now?" she asked Usha quietly as they navigated through the crowd toward the courtroom doors. "All these people watching?" "Just for today," Usha assured her, though she wasn't entirely certain. Cases that become symbols often lose their privacy, with public interest sometimes overshadowing the individual at the center. "Remember that regardless of who's watching, this hearing is about your case, your rights, and your freedom." Inside the courtroom, James Preston was already at the prosecution table, reviewing documents with an associate. He acknowledged Usha with a professional nod as she and Maria took their places at the defense table. The gallery filled quickly, with court officers eventually closing the doors when seating capacity was reached. Judge Eliza Sandoval entered precisely at 9 o'clock, her demeanor reflecting neither the gravity of recent events nor any particular bias regarding the case before her. After the customary rising and introductions, she addressed the attorneys directly. "Counsel, I've reviewed the case file thoroughly, including the transcripts from proceedings before Judge Blackwell. I'm aware of the unusual circumstances that have brought this matter to my docket." Her tone was matter-of-fact, establishing that while she recognized the case's history, she would not be defined or limited by it. "Today, I would like to hear arguments specifically addressing the constitutional dimensions of the charges against Ms. Gonzalez, as I believe these issues are central to determining how we proceed." This direct invitation to present exactly the arguments Judge Blackwell had attempted to silence represented more than a procedural opportunity. It was a tacit acknowledgement that the previous approach had been fundamentally flawed. Usha rose, feeling a particular clarity as she prepared to deliver the constitutional analysis she had originally developed but never been permitted to fully present. "Thank you, Your Honor. The defense submits that the charges against Ms. Gonzalez implicate core First Amendment protections in 3 distinct ways." What followed was a methodical exposition of constitutional principles applied to Maria's specific actions during the protest. Usha highlighted Supreme Court precedents, establishing that organizing and participating in peaceful demonstrations fell squarely within protected speech and assembly rights. She addressed the prosecution's characterization of certain acts as crossing the line into unprotected conduct, demonstrating through video evidence and witness statements that Maria had consistently worked to maintain the protest's peaceful character. Throughout this presentation, Judge Sandoval listened attentively, occasionally asking probing questions that suggested genuine engagement with the constitutional arguments rather than dismissal. The contrast with Judge Blackwell's approach was stark and unmistakable, reinforcing the justice system's capacity for self-correction when its principles were properly applied. When Usha concluded, Judge Sandoval turned to the prosecution. "Mr. Preston, the government's response to these constitutional arguments?" James Preston rose, his expression suggesting internal conflict between institutional position and personal recognition of the case's weaknesses. "Your Honor, the government acknowledges the First Amendment implications raised by defense counsel. While we maintain that certain actions cross the line from protected expression to unlawful conduct, we recognize that this determination involves complex constitutional balancing that wasn't fully explored in previous proceedings. This measured concession, stopping short of abandoning charges but acknowledging the legitimate constitutional issues at play, represented a significant shift from the prosecution's earlier stance." Judge Sandoval nodded, recognizing the nuanced position Preston had taken. "Given the constitutional dimensions properly raised by the defense and acknowledged by the prosecution, I am ordering full briefing on these issues before we proceed further." Judge Sandoval's ruling represented both procedural fairness and judicial humility, a recognition that complex constitutional questions deserved thorough consideration rather than summary dismissal. Defense will submit their brief within 14 days. Prosecution will have 14 days to respond, and we will reconvene for arguments 3 weeks from today. This outcome, while not the immediate dismissal Maria might have hoped for, represented substantial progress. By centering the constitutional questions that Judge Blackwell had marginalized, Judge Sandoval had fundamentally reframed the case in a manner that gave Maria's defense its strongest possible foundation. As the hearing concluded and the courtroom began to clear, an unexpected figure approached the defense table. Harold Winters, the chief judge who had intervened during the confrontation with Judge Blackwell. His presence in a colleague's courtroom for a routine status conference was unusual enough to draw notice from the attorneys still present. "Ms. Vance," he greeted Usha with formal courtesy, "might I have a word, in private?" Ensuring Maria was comfortable with her supporters, Usha followed Chief Judge Winters to a small conference room adjacent to the courtroom. Once the door closed, his formal demeanor softened slightly. "That was well argued," he began, the compliment seeming genuine, if somewhat restrained. "Your constitutional analysis was precisely what Judge Blackwell should have allowed from the beginning." "Thank you, Your Honor," Usha replied, curious about the purpose behind this unusual conversation. "I wanted to inform you personally before the public announcement this afternoon," Winters continued. "The Judicial Council has received Judge Blackwell's resignation, effective immediately. He has elected to retire rather than face the completion of our review process." This development, unexpected in its timing, though perhaps inevitable in its outcome, represented the most concrete consequence yet of Usha's courtroom stand. A federal judge with lifetime appointment had chosen to end his career rather than defend conduct that had been exposed as fundamentally at odds with judicial principles. The Council has also unanimously approved the formation of a permanent committee on judicial conduct and procedural fairness, Winters added, his tone suggesting this was the development he considered most significant. "We would like you to consider serving as one of the non-judicial members." The invitation represented institutional recognition of a principle rarely acknowledged so directly, that the justice system required perspectives from outside its hierarchical structures to maintain its integrity and purpose. By extending this role to the very attorney who had challenged judicial authority, the Council was demonstrating uncommon institutional wisdom. "I'm honored by the invitation, Your Honor," Usha responded carefully, "but my primary commitment remains to my clients, including Ms. Gonzalez." Winters nodded, unsurprised by her reservation. The committee would meet quarterly, with additional consultation as needed. It need not interfere with your practice. Consider it carefully. Sometimes change is most effective when working both outside and within institutions. As they parted ways, Usha rejoined Maria and her supporters in the hallway, where news of the successful hearing had already generated a mood of cautious celebration. The constitutional arguments that had been silenced were now centered in the case, A judge open to their substance had replaced one who had dismissed them, and the institutional reforms sparked by their confrontation were taking concrete form. "What happens now?" Maria asked as they descended the courthouse steps, the autumn sunlight casting long shadows across the plaza. "Now we prepare the strongest possible constitutional brief," Usha replied, her professional focus returning to the immediate needs of her client rather than the broader movements their case had sparked. "Judge Sandoval will give it fair consideration. That's already more than we had before." What neither of them could fully appreciate in that moment was how the ripples from their case would continue to expand, through the coalition's advocacy, through the students' empirical research on judicial conduct, through the reformed procedures that would emerge from the new committee, and through the subtle but significant shift in courthouse culture that had begun when one attorney refused to accept that constitutional principles could be silenced for the sake of judicial convenience or control. As Maria rejoined her children and supporters, Usha remained briefly on the courthouse steps, watching the intersection of individual and systemic justice unfold before her. The next chapter would not be written in dramatic confrontations, but in the patient, persistent work of translating principle into practice, ensuring that what had been won through courage would be sustained through commitment to the deeper promise of equal justice under law. 3 months after the confrontation in Courtroom 7A, the landscape of justice in Westlake had undergone a transformation both subtle and profound. The federal courthouse still stood with its imposing columns and marble steps, but within its walls, the dynamics of power and procedure had shifted in ways that rippled through every case and courtroom. On a bright winter morning, Usha Vance climbed those courthouse steps alongside Maria Gonzalez, both women carrying themselves with the quiet confidence of those who had faced the system's resistance and emerged victorious. The constitutional brief Usha had prepared following Judge Sandoval's hearing had ultimately led to the dismissal of all charges against Maria, with the judge's 40-page opinion establishing a precedent that had already been cited in similar cases throughout the circuit. "Still feels strange coming here and not being afraid," Maria commented as they passed through security, the officers greeting them with respectful nods that would have been unimaginable months earlier. Today's visit was not for Maria's case, but for the inaugural public session of the Committee on Judicial Conduct and Procedural Fairness. After careful consideration, Usha had accepted Chief Judge Winter's invitation to serve as a non-judicial member, recognizing that the perspective she brought as both a practicing attorney and the catalyst for these reforms was uniquely valuable. The committee meeting was being held in Courtroom 1, the largest in the building, to accommodate public attendance. As Usha and Maria entered, they found the space nearly filled. Attorneys, court staff, law students, and community members gathered for this visible symbol of institutional change. Among the faces Usha recognized were Elena Diaz and her fellow students, whose research on judicial conduct patterns had been published in the Harvard Law Review and was now being used as a model for similar studies in other districts. Chief Judge Winters opened the session with remarks that acknowledged both the painful catalyst and promising potential of the committee's formation. "The integrity of our justice system depends not merely on following rules, but on continuously examining whether those rules serve their intended purpose," he stated, his gaze moving deliberately across the diverse gathering. Recent events in this courthouse have reminded us that procedural fairness is not an abstract ideal, but a practical necessity for justice to be both done and seen to be done. As the committee's agenda unfolded, Usha found herself struck by how institutional change, when it finally comes, can appear both revolutionary and obvious, as though everyone should have always recognized the need for transparent standards for judicial recusal, meaningful review of discretionary rulings, and procedural protections for constitutional arguments. The committee's work that day included reviewing proposed amendments to local rules, establishing a confidential feedback mechanism for attorneys to report concerns about judicial conduct without fear of retaliation, and creating a training program for new judges that emphasized constitutional obligations alongside technical procedures. During a brief recess, Usha found herself alongside Catherine Morrow, the federal public defender, whose coalition had evolved from an emergency response into an ongoing force for systemic improvement. "Sometimes I can hardly believe what's happened in 3 months, Catherine commented, gesturing toward the judges' bench where 3 federal judges now sat alongside attorneys, scholars, and community representatives in a deliberative body that would have been unimaginable under previous court administration. Judge Franklin actually asked me yesterday if I thought a proposed ruling adequately protected my client's constitutional rights. Asked me before ruling. This small anecdote captured the subtle but significant cultural shift that had occurred throughout the courthouse. The walls between bench and bar remained appropriately distinct, but they had become more permeable to the exchange of perspectives necessary for justice to function as intended. Near the back of the courtroom, Samuel Vance observed the proceedings with the measured satisfaction of someone who had witnessed many cycles of institutional resistance and reform over a long legal career. When the committee reconvened, he watched his daughter present findings on disparities in how constitutional arguments were received across different types of cases: civil versus criminal, corporate versus individual, wealthy versus indigent litigants. Her presentation reflected the same principled conviction that had fueled her confrontation with Judge Blackwell, but now channeled into systematic analysis and structural recommendations. The courage that had been required to stand alone in courtroom 7A had evolved into the steadfastness needed to transform a moment of crisis into lasting change. As the formal session concluded, the courtroom transitioned into a more casual gathering, with committee members engaging directly with attendees. Judge Sandoval, who had recently been appointed to fill the vacancy left by Judge Blackwell's resignation, approached Usha with a colleague from the Eastern District, who was considering implementing similar reforms. "Your father tells me you've been receiving inquiries from bar associations across the country," Judge Sandoval mentioned. "It seems Westlake is becoming something of a model for judicial accountability." Usha acknowledged this with characteristic modesty. The principles weren't new, just the willingness to examine how well our practices actually align with them. Across the room, Maria Gonzalez was engaged in animated conversation with several community members who had attended the session. Her experience had transformed her not just from defendant to free citizen, but into an advocate for procedural justice, who now regularly brought community perspectives into courthouse spaces that had previously seemed inaccessible. As the gathering began to disperse, Usha found herself momentarily alone in a quiet corner of the courtroom, reflecting on the journey from confrontation to collaboration. She recalled the intensity of that moment when she had decided to challenge Judge Blackwell's attempt to silence her constitutional arguments, the split-second weighing of professional risk against principled obligation that had changed not just her client's case, but her own career trajectory. Elena Diaz approached, her expression betraying the mixture of admiration and uncertainty often found in those still forming their professional identities. "Do you ever wonder what would have happened if you hadn't spoken up that day?" she asked. "If you'd just accepted the judge's limitations and found another way to defend your client?" Usha considered the question thoughtfully. "I think about the alternatives less than I think about the responsibility the outcome created. One confrontation doesn't transform a system, it just creates an opening. The real work happens in all the days that follow." This perspective captured what many observers had missed in focusing on the dramatic moment in courtroom 7A. While Usha's stand had indeed been the catalyst, the substantive changes had come through the patient, detailed work of many hands, the coalition's documentation of patterns, the students' empirical research, the Judicial Council's willingness to examine its own structures, and countless attorneys who had begun asserting constitutional arguments more confidently in courtrooms throughout the district. As Usha and Maria departed the courthouse together, they paused briefly on the same steps where the confrontation's aftermath had begun to unfold 3 months earlier. The winter sun cast their shadows long across the plaza, where a small group of protesters exercised the very rights Maria had been prosecuted for asserting. Their peaceful assembly now protected by both constitutional principle and local practice in ways that had been more theoretical than real before. "Do you think it will last?" Maria asked, watching the demonstration with the practiced eye of someone who understood both the power and fragility of civic participation. "Everything that's changed?" Usha followed her gaze, considering the question with the seriousness it deserved. Systems have inertia in both directions. They resist change and then resist changing back. What matters is that people remember that the rules and procedures exist to serve justice, not the other way around. As they descended the steps, moving from the formal space of the courthouse into the community beyond. They carried with them the knowledge that what had begun as one attorney's refusal to be silenced had evolved into something more sustainable, a recalibration of the relationship between judicial authority and constitutional principle, between institutional power and individual rights. The courtroom that had erupted in that pivotal moment remained a place where future conflicts would be resolved and future principles tested. But its foundations now included the memory of a confrontation that had reminded all who witnessed it that justice depends not only on laws and procedures, but on the courage of those willing to defend its deepest promises when they matter most.